Water Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
Right out of the gate, this is not a normal courtroom interaction. Within seconds, the defendant rejects her legal identity and replaces it with a completely different framework of who she claims to be. And if you're confused, you're not alone, because the court is about to be just as confused. What you're hearing here is language often associated with sovereign citizen-style arguments, where individuals believe their legal name is separate from their real identity. But here's the key issue. Courts don't operate on personal belief. They operate on legally recognized identity. So instantly, we have tension, not about guilt or innocence, but about something even more basic, who this person legally is. And trust me, when identity itself is disputed, everything that follows becomes a legal minefield.
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint?
And just like that, the judge raises the stakes dramatically. This isn't just a warning, it's a procedural reality. If the court cannot confirm your identity, it has the authority to detain you and verify it through fingerprints. That's because identity is foundational in any legal proceeding. Without it, the system literally cannot function. Notice how quickly things escalate from confusion to potential custody. That's the courtroom saying you can challenge many things, but not the basic structure of how the court identifies you. So now the defendant is at a crossroads: comply with the system or risk immediate consequences.
If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue.
This is a huge moment, and it changes everything. When a defense attorney raises the issue of competency, they're essentially saying, we need to pause. This person may not fully understand what's happening. And legally, that matters more than anything else right now. Because if someone is not competent, the court cannot proceed with the case in the normal way. What triggered this? Likely the defendant's refusal to acknowledge identity, the unusual language, and the disconnect from standard legal procedure. So now the case shifts from what happened to whether the defendant can even participate in the process. That's a massive pivot.
Issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
Pursuant
asking
to the
for
statute.
anything, and that's, I mean, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well,
Here's where the disconnect becomes crystal clear. The defendant is attempting to settle the case, but the reasoning she's using has no recognized meaning in a court of law. Terms like cardholder and principal relationship might sound official, but legally they carry zero weight here. And you can see it in the judge's reaction, complete confusion. Because in court, language has to align with established legal definitions and procedures. This moment highlights something critical. You can't win a legal argument using terms the law itself doesn't recognize. So while she believes she's making a valid move, the court literally cannot process it as one.
I want to settle because I'm the card holder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for 90.
June 6th at 9 a.m.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Jade Lathan.
Mr. Canopy for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We've reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Bond continued. Yeah.
Thank you, Your Honor.
Now we're entering the emotional core of the case. Listen closely, because this isn't just defiance anymore, it's belief. She's laying out her story, her frustration, her claims of being wronged, and the impact this situation has had on her life, school, reputation, everything. And this is where things get complicated, because from a human perspective, you can hear sincerity. You can hear someone who truly feels they've been treated unfairly. But from a legal perspective, the court still has to operate within strict rules of evidence and procedure. And that gap between how someone feels and what the law recognizes is exactly where this tension lives. So here's the question for you. Can someone genuinely believe they're right and still be completely wrong in the eyes of the law?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly,
And here it is, the final decision that brings everything together. The judge denies the motion to dismiss and, importantly, explains why. The delays in the case weren't caused by the prosecution, they were caused by the defense. That directly shuts down any argument about a violation of the right to a speedy trial. This is how courts operate, not on emotion, not on belief, but on documented timelines and procedural facts. And in this moment, you can see the full contrast. On one side, a defendant driven by identity and conviction. On the other, a legal system driven by rules and structure. And when those two collide, the law almost always wins. So now I'll ask you, was this a misunderstanding of the system or a deliberate rejection of it?
not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.